In this video, we explore the key mechanisms for resolving disputes in the complex landscape of international relations. Dispute redressal mechanisms in IR refer to the processes and institutions used by states to resolve conflicts and disagreements peacefully. These mechanisms are crucial for maintaining stability, promoting cooperation, and preventing the escalation of disputes into violent conflicts. Diplomacy, direct talks between states, facilitated by diplomats, to find mutual solutions. Mediation involves a neutral third party facilitating negotiations between conflicting parties. Arbitration, formal process where parties submit their case to impartial arbitrators, whose decision is binding. Adjudication, resolving disputes through legal processes like international courts or tribunals. Regional organizations like EU, or ASEAN have conflict resolution mechanisms. Bilateral, multilateral treaties, agreements with procedures for negotiations, mediation, or arbitration. The peaceful settlement of disputes is a fundamental principle of international law and relations, aimed at resolving conflicts without resorting to force or violence. Negotiation, direct talks between parties to reach a mutually acceptable solution. Negotiation allows for flexibility and can address a wide range of issues. Mediation involves a neutral third party facilitating negotiations. Mediators help parties explore options, improve communication, and find common ground. Arbitration, binding resolution by a neutral arbitrator or panel based on evidence and arguments presented by parties. Arbitration offers a formal process with legal certainty. Judicial settlement, cases brought before international courts or tribunals, such as the ICJ, where legal principles and treaties are applied to reach a decision. Good offices, diplomatic efforts by a third party to assist parties in resolving disputes, often used in conjunction with other methods. Conciliation, a process where a conciliator helps parties identify issues, clarify interests, and develop solutions, often leading to a mutually agreed settlement. Peacebuilding, beyond immediate dispute resolution, peacebuilding focuses on addressing underlying causes of conflicts, promoting reconciliation, and building sustainable peace. Chapter 6 of the UN Charter focuses on peaceful settlement of disputes. It emphasizes negotiation, mediation, and other peaceful means to resolve conflicts, promoting international peace and security. The chapter highlights the importance of diplomatic efforts, regional organizations' roles, and adherence to international law in preventing conflicts and maintaining stability. Negotiation is the process of direct discussions between parties to a dispute with the goal of reaching a mutually acceptable agreement. It is considered the most informal and flexible method of dispute resolution. Negotiation can take place bilaterally, between two parties, or multilaterally, involving multiple parties. Key features: voluntary, parties engage in negotiations willingly. Direct communication, direct interaction allows for clarity and understanding of each party's concerns. Flexibility, parties have the freedom to propose and discuss various solutions. Confidentiality, negotiations can be conducted in private to encourage open dialogue. Mediation involves the intervention of a neutral third party, the mediator, who assists disputing parties in reaching a mutually acceptable agreement. The mediator facilitates communication, helps clarify issues, and explores potential solutions. Neutrality: the mediator remains impartial and does not take sides. Facilitative approach: the mediator guides discussions but does not impose solutions. Confidentiality: mediation sessions are often confidential to encourage candid discussions. Informality: compared to formal processes like arbitration, mediation is less structured. Example: United Nations mediators assisting in peace talks between conflicting parties in a civil war. Conciliation is similar to mediation but often involves a more active role by the conciliator in proposing solutions and bridging differences between parties. It aims to promote understanding and reconciliation between conflicting parties. Features: active involvement. The conciliator actively participates in finding common ground and proposing solutions. Emphasis on reconciliation. Conciliation focuses on repairing relationships and fostering cooperation. Flexible process. Parties have the flexibility to explore various options during conciliation. Arbitration is a formalized process where parties to a dispute agree to submit their case to an impartial arbitrator or panel of arbitrators. The arbitrators review evidence, hear arguments, and make a binding decision, known as an award, that parties must abide by. Key features: binding decision. The arbitrator's decision is final and legally binding on the parties involved. Impartiality. Arbitrators are neutral and independent, ensuring fairness in the process. Confidentiality. Arbitration proceedings can be kept confidential if desired by the parties. Enforceability. Awards can be enforced through national and international legal mechanisms. Example: international commercial arbitration to resolve disputes between businesses from different countries. The judicial settlement involves resolving disputes through legal processes, typically before international courts or tribunals. The International Court of Justice (ICJ) is the principal judicial organ of the United Nations and plays a significant role in adjudicating disputes between states based on international law. Key features: negotiation. Direct talks between parties to reach a mutually acceptable solution. Negotiation allows for flexibility and can address a wide range of issues. Mediation involves a neutral third party facilitating negotiations. Mediators help parties explore options, improve communication, and find common ground. Arbitration. Binding resolution by a neutral arbitrator or panel based on evidence and arguments presented by parties. Arbitration offers a formal process with legal certainty. The International Court of Justice (ICJ) is the principal judicial organ of the United Nations, established to settle legal disputes between states and provide advisory opinions on legal questions. It operates based on international law and treaties, with judges elected by the UN General Assembly and Security Council. The ICJ's decisions are binding and contribute significantly to the development and interpretation of international law. Functions of the ICJ: adjudication of disputes. The ICJ serves as a judicial forum for the peaceful resolution of legal disputes between states. It hears cases and delivers binding judgments based on international law. Interpretation of treaties. One of the ICJ's functions is to interpret international treaties and agreements when disputes arise regarding their interpretation or application. Advisory opinions. The ICJ provides advisory opinions on legal questions referred to it by UN organs and specialized agencies. While advisory opinions are non-binding, they carry significant legal weight. Legal clarity. Through its judgments and opinions, the ICJ helps clarify legal principles and rules of international law, contributing to the development of a coherent legal framework for international relations. Role of the ICJ in peaceful settlement. Promoting rule of law. The ICJ promotes the rule of law in international relations by providing a peaceful and orderly mechanism for resolving disputes based on legal principles, preventing conflict. By offering a forum for states to resolve disputes through legal means, the ICJ contributes to preventing conflicts from escalating into armed confrontations, fostering diplomacy. The ICJ's involvement in dispute resolution encourages states to engage in diplomatic efforts and negotiations, facilitating dialogue and cooperation.
Thank you for watching. We're thrilled to have you here and hope that you find our content informative, engaging, and entertaining. Be sure to like, share, and subscribe, and don't forget to join us for further updates.